All right, well, welcome back. We're going to start video number 2 on week number 1, and we're going to continue on where we started off talking about the legal structure and the United States legal structure and civil dispute resolution. So let me share the screen again, and we're going to go into our PowerPoints that are going to our week. And into the PowerPoints and go in where we left off. Which is right here. All right, kind of went through where cases can be brought, and so now we're going to look at the situation where the parties have not been able to resolve their matter through negotiations, mediation, or other issues. So what we're talking about in the outdoor industry law area, on the service side, lawsuits may arise when there's injury to guests. On the product side, lawsuits may arise when there are either defective products or products that don't comply with warranties and that sort of thing. And then there'll be some regulatory law that would apply, such as laws not complying with appropriate labels and that sort of thing. So when the parties, and we'll focus mainly on private parties at this point, not lawsuits brought by agencies, can't agree, then we end up in the civil dispute resolution process, which is basically what we call litigation, lawsuits. And one of the jobs of us as business people, and certainly your attorneys who are working with you, is to mitigate the legal risks so as to not end up in litigation. Litigation is expensive, time-consuming, and takes the business away from what it does best, which is selling products, making and selling products and services, and providing services, not spending time in the civil dispute process. So a lot of what we're going to focus on mainly in this course is how we can draft contract provisions, release documents, and those types of and policies for companies, for your companies, to limit the potential exposure to legal liability. And so now we're just going to go through very quickly what a lawsuit looks like, so that you'll be able to first recognize you don't want to get in one, and secondly, be able to assist sufficiently with counsel and know in part where, that if you do end up in a lawsuit, a lot of what is written and said and done before the lawsuit comes in as potential evidence, either in support or it may be evidence that doesn't help your cause so much. So let's go through it quickly. Civil dispute resolution process starts with what we have up here, which is the pleading stage. Simply means that the injured party, who is known as the plaintiff, will file a complaint. They file it with the appropriate court or the appropriate jurisdiction, which we just went through, and serve the complaint and a summons, which says that on the defendant, company, obviously sometimes, and the summons will indicate how long the defendant has to answer the complaint. In other words, state where it disagrees with the complaint in the particular case. So that's the pleading stage, and it's usually very general, pretty general in terms of what will go into a complaint to begin a lawsuit. The next, some pretrial motions, if there's a basis to dismiss the case, maybe on jurisdictional grounds, or that would actually be a special appearance, but in any event, or if you think you could get the case as a defendant thrown out, just stating that the complaint as written doesn't, as a matter of law, does not state a claim that for which the plaintiff can receive compensation, then you might move to dismiss on the pleadings, they call it. All right. Discovery. This is the stage of the lawsuit that is unbelievably time consuming and burdensome on both parties. They're both companies, individuals, but certainly from a company standpoint. And it's just like it sounds. It's called the discovery phase because we believe in an adversary system of justice in our country. And that is that if all the information that is related to a particular set of facts that give rise to a lawsuit, if all of that information is known and is presented to each party truthfully and fully, that we will arrive at the truth. And ultimately, if you go to trial, it'll be a jury that would determine what the truth is as it relates to the facts, and the judge will instruct the jury on how to apply the law to whatever facts that the jury finds. You can have what they call a bench trial as well, where both parties agree just to have a judge hear the case as the fact finder and not a jury. Even the discovery phase, when a company is sued, you basically have to freeze a snapshot of all information that the company has that could conceivably lead to the admission of discoverable evidence at trial. In other words, it's a huge net. All information that could lead to the discovery of admissible or evidence that may be admissible at trial. So when you get served with a summons and complaint, or that you are certain that you're going to be sued, there's a duty on the company to make all that information that could lead to the discovery of admissible as evidence they have to be able to produce that to the other side when the other side asks for that information. So you got these tools that both parties have, the plaintiff and the defendant. The one I was just focusing on is this production of documents. And so you can imagine every email, every text, every social media post, obviously any documents, physical or digital, that could conceivably lead to the discovery of admissible evidence have to be maintained for purposes of the lawsuit. And if a company is found to not meet that duty and allow evidence to be destroyed or made unavailable to the other party, the case can actually, the judge, if the bad enough case, could rule just against that plaintiff, or excuse me, that defendant, that company, or issue a ruling that to the fact finder, normally the jury, that information you can assume would have been detrimental to the party that destroyed it. So really important. So you may end up, if you end up in a lawsuit, you're going to end up figuring out a way to maintain all your documents and be prepared to present them to the other side when you get a request for production of documents. Parties that know something about the case within your company are going to be subject to depositions, which is simply where you sit around a table, swear under oath that you're going to tell the truth, the whole truth, and nothing but the truth. And attorneys will be grilling you from going over things that you'll say have nothing to do with the lawsuit, but they will have quite a bit of free reign to ask questions that are related somewhat. I mean, I've seen they can go all the way back to your birth, it seems like. But and I did litigate for about 10 years before I started in on the corporate side. That's one of the reasons I truly believe that it often is a waste of time and money. But anyway, so you want to stay out of litigation, but you're subject to depositions where you're asked questions about your involvement, what you may or may not know about the lawsuit. Also, written interrogatories, you will be assisting your attorneys in answering questions that might be presented to your company. Those questions are answered under oath by an officer or someone who can swear to the veracity of the answers given. And then a thing called admissions, which is a document where you send the other side and get them to admit facts that they can't deny. Like if you're involved with let's just say another rafting incident, and one of the issues was it was raining. The other side may submit a request for admission to admit that it was raining on the day that the incident occurred at the place where the incident occurred. All right, so suffice it to say, discovery takes a lot of time and unbelievable distraction for the operation of the business. Then we end up in this situation where, in theory, what has happened through the discovery phase is that both sides basically have all the information that the other side has that's relevant to the case. So once that has occurred, this is really important from the outdoor industry standpoint as it relates to release of liability forms on the services side when you have your guests sign a release, and on the product side when you sell equipment that you want to indicate does not have for instance, an implied warranty of merchantability or fitness for a particular purpose. So you will put language in your terms and conditions to disclaim those warranties. So at this stage, what would happen is the company, normally the defendant, if you're being sued, obviously, would move for a motion for summary judgment, which basically is a request to the court that there's no need for a trial, because all a trial does is determine the facts. So the moving party, the one that wants the case dismissed, for instance, in the case you're going to be briefing, the Ohio Valley Ranch case, in that case, the Ohio Valley Ranch, which was providing the horseback rides, wanted to have the court rule that the release that the guest signed was valid and would release the ranch from any liability for the horseback injuries that would be sustained as a result of the horseback ride. That comes up in the summary judgment phase. After you have all of the depositions, you know whether the person signed it because they said they did, whether they could read it, how it was presented to them, because in your depositions you've asked witnesses that. So you put all that information in your brief in support of motion for summary judgment. So you as business people will be assisting with, what happened, and say we don't need a trial, because if you take all the information we have, let's use the Ohio Ranch matter, and the Ohio Ranch is moving for summary judgment. They say you take all of the information that we have so far, all the evidence that we have so far in this case, and there is no way that a reasonable jury could conclude that the release was not valid. In other words, that as a matter of law, now that we know that she signed it and all that sort of thing, the release is valid and the injury that she sustained is one that is released. So we don't need a jury to tell us to determine any facts. And the burden is very strong on the party that's asking for no trial to show that there's no genuine issue of a material fact that would allow the jury to enter a verdict against us. So it's a great tool. And again, where it comes up in the services side is when the outdoor industry provider is arguing that the release should be effective to limit this liability for this injury, that should be released from the liability for the damages sustained as a result of the injury, that we don't need a trial to determine that is what happened, or that is the effect of the release. But you need to go through discovery to make sure how it was presented, if anything was said to lead the party to say, well, they didn't really know what they were signing, or that kind of thing, or that it was said, don't worry about it, so that all of the information is there, so that you can say this was appropriately signed, and as a matter of law, it's effective. So you want to get the case thrown out before you go to trial. That's the goal of a summary judgment. On the product side, you do the same thing with showing that you have documentation in your terms and conditions that indicate that if for instance, if the product failed to just perform as it ordinarily would, but it complied with your other warranty or guarantees or warranties in your terms and conditions, that the contract that was signed by the parties contained language that disclaimed this warranty of merchantability, i.e. that the product would perform as in the ordinary course of business without objection in commerce. So we'll talk more about express warranties and implied warranties. So that's where summary judgment is used. You want to avoid trial. If you end up having to go to trial, here's the slide on how a trial works, all the way from jury selection through opening statements through a judgment. I'm not going to spend time on this. You can look at it, and if you have any questions, we can talk about it in our weekly meeting. All right, so next, this is just, I just want to make one point on post-trial or verdict motions is, let me go back, is this. If you win a case, you may be subject to appeal. If the other side can come up with an error of law, then you might have an appeal, and the effect of the the verdict or award is kind of held in abeyance until the appeal is heard. So again, a delay in time and that sort of thing. But if you prevail in a case, so if you're say on the product side and you want to bring a claim against a vendor, for instance, one of the first things you need to do is make sure that you think you're going to win on the facts, that you have a good case and the law, but that the party that you're suing has money. Because if you chase a lawsuit where there is no money at the end of the rainbow, then all you've done is wasted a lot of time, money, negative energy, and taken yourself away from your business. So you want to make sure that there's either insurance or that the company that you're dealing with is financially able to pay a verdict, a judgment, and that you can get at that money through some type of legal means like guard judgments, where you attach bank accounts, that sort of thing. If it's an individual, you want to make sure that they have substantial assets to be able to pay, or who pays most of the time in injury cases, right, is insurance companies. So we want to look at, and we will, of course, throughout this class, what insurance companies can obtain to help, again, pay some losses if necessary. Hopefully we'll draft policies, follow policies and contracts, draft contracts and release documents in such a way that we won't have to draw on the insurance, but you certainly want to have it available. So point of it is, make sure that the party that you as a company decide to sue is going to be able to pay the judgment, and that you'll be able to get at those assets. All right. This is something that business people really should focus on, is alternative dispute resolution. And that's just like it sounds. It means just doing something other than bringing a lawsuit. So you want to draft your agreements and your releases in such a fashion that if there is an injury or damage caused by your products, that you can look to your contracts and say, hey, in a release situation, you might say to the, at least the attorneys for the person that's been injured, we have a valid release, and feel horrible about what happened, but from a legal standpoint, the claim has been released, so that you're in a strong position in negotiation and negotiating a reasonable and just settlement. Perhaps paying nothing, but in negotiation, there's a saying that both parties, a good deal is a deal where both parties are a little upset. So any event, from the product side, again, draft your documents so that you're in a position of strength to argue that that you haven't breached whatever warranty or that there might be as it relates to the particular type of product that you're selling and what the party is complaining about. Put limitation of remedies. We'll get into that, where you limit the amount that a third party, or say a merchant purchaser of your goods, could win if they were successful in a lawsuit. So limit your liability, limit your remedies, and that sort of thing. Get in a position where you can negotiate a settlement. Arbitration. That's simply, I'll just say, it's a trial in front of an arbitrator. You might have one arbitrator, you might have three arbitrators, and it is supposed to be less expensive, less time consuming. There might be less discovery, and the parties in their contracts and agreements can mandate that if something comes up under, say, your purchase of your invoice or purchase order for goods, it has to go to arbitration, so that if one party or the other files a lawsuit, it can actually be dismissed on the basis that, hey, we have to do this in arbitration. You may decide that you want an arbitration because you don't want to have to face a jury on the situation, on the facts of the case. You may want arbitration when you're talking about technical aspects of, say, products and design that a judge, a retired judge, oftentimes, or arbitrators or experts in the field, might be arbitrators, would know more about and be able to understand the nuances. So that would be one reason to have arbitration. I've seen arbitration in employment agreements, so that if the employer violates the employment agreement, it goes to an arbitrator instead of a jury. Juries are oftentimes much more sympathetic to perhaps employees than an arbitrator might be, and that it's more just business with the arbitrator. I've been through arbitrations. Sometimes sometimes they are long and lengthy and expensive. Sometimes they're quick. I arbitrated on behalf of companies against union grievances throughout the country, and there we could arbitrate. If someone had been terminated or demoted or something, we could arbitrate those very quickly and efficiently for the companies. So it's a tool to be aware of, and talk to your attorneys. You'll need to talk to your attorneys about what's going to be best based on what the potential risk is of your business. Mediation is where both parties go in front of a neutral third party and really just simply discuss, the third party is there. Both parties present their case basically to the mediator, sometimes separately, and then the mediator tries to bring the two parties together to help with a negotiation and a settlement. And it can be a binding mediation. It can be an award, just like the arbitration is. You usually don't want to go through it unless it's binding, and meaning that it has the same impact as a judgment rendered by a court. So mediation, you can do non-binding or binding, and binding means that if you do, basically what will happen in a mediation, if you do reach an agreement, the parties agree to what that judgment would look like if either party didn't perform pursuant to the agreement or the settlement that's reached in mediation. So that's alternative dispute resolution. All right, I wanted to briefly go into a little bit more of administrative law, going back to the sources of law, because I noticed that the author just glosses over this. Agencies, whether it's the EPA or the FTC or the Forest Service or the BLM, or entities that are involved with the outdoor industry and licensing authorities that that you in the outdoor industry know that you have to comply with regulations. And I'll be asking you all to help me with those agencies that you deal with on a regular basis that issue licenses, monitor what you can and can't do, and enforce regulations that affect your business. In any event, I wanted to just let you know how agency law works, basically. And that is, an agency is created by the legislature pursuant to a statute, and that statute is called an enabling, just like it sounds, enables the agency to do its job. An example would be, for instance, OSHA. If you're operating your business, and then you will need to comply with the Occupational Safety and Health Administration, which is created under the statute, and that's where that hot link is right there to the OSHA statute that created OSHA. And that statute comes from, in that case, the federal legislature. So it's the agency only has the authority that's delegated to it by the legislature. And if an agency is acting outside the scope of what is set forth in the enabling statute, that is a defense that a company might have to an action brought by the agency. So that's one way to look at it. The agencies exist in the executive branch. And so once, for instance, like OSHA has been granted the authority to implement a safe work environment, then OSHA develops regulations. And these are, as most of you know, pages and pages, thousands of pages of regulations that you may have to comply with to obtain your permit or that sort of thing. Or, if you're looking at like the National Environmental Policy Act, which the EPA enforces, you'll have all kinds of regulations that you have to comply with. Those regulations, they are put in place after a rulemaking process, meaning there's public and industry comment and all that sort of thing that ends up in the publishing of a final order, final regulation. And then if the agency decides to bring an action against the company, say for violating an OSHA regulation, then the agency, in addition to creating rules and enforcing those rules, gets to actually adjudicate those rules. In other words, they're called, like a mini judiciary within the agency, and you have administrative law judges. And those judges will look at the facts and the law and determine whether there has been a violation. For instance, let's say go again with an OSHA violation. If the agency rules against the company in the final agency action, the company would have the right to appeal to a court to indicate that the agency acted outside of its scope and authority, or that there was really no substantial evidence presented that would support the agency's position, or for instance, say a denial of a permit that you might have. You'd be able to go to court and say if this is the case, there was no substantial evidence presented to the administrative law judge that would support the agency's position. That is really tough. That's a tough standard to meet. And I think I get into this here. Yeah. The agency, when you're challenging agency action, you basically have to prove that the agency didn't have any substantial evidence. And the courts defer to the agency. So all the courts really do is they look at the record that had been kept by the agency, and I mean that as a transcript, all the evidence that was presented, and it simply looks to see if there was evidence to support the agency's decision. They don't look to whether it's right or wrong. They don't weigh the evidence that, well, there wasn't enough evidence for the agency to decide that. It's basically the agency has to have acted arbitrarily and capriciously, which means without reason. And so, as you can probably gather, that means it's really, really tough to have agency decisions overturned. So because of this standard of review, they call it, so is what it's known as. So again, the judiciary, in looking at an agency action, figures the agency's the expert, and they defer to the agency for purposes of adjudicating matters, and generally will only overturn the agencies if they just acted arbitrarily and capriciously, in other words, no evidence to support it, or if they made up the law. If, for instance, an agency determines that the law should read and it really reads or, and if that's the case, that they can show that the agency was clearly not acting consistent with the regulations that they put in place or the statute under which the regulations were originally issued, then you have a challenge that it's just that they were misinterpreting the law. And so there is a basis for challenging agency actions, but I guess the long-winded position on this is you want to try and be in a position to prevail at the agency level, because it is difficult to overturn. Take a look at these hot links. It's just some additional information on a Chevron case and the Colorado Oil and Gas Commission case that we had before, that kind of was in effect before our last election. All right. Okay, rather than break this up into another video, let's go right into briefing a case. So I'm going to go back to our Blackboard week 1 and go through this assignment with you. If you look at the assignment, it says use the Ryan versus Friesenhahn case down here to learn how to brief a case. And when I say brief a case, that means facts, material facts of the case, issue for the court to decide, the decision of the court, and the reasons the court ruled the way that it did. We'll call that shorthand FIDRE: facts, issue, decision, reason. So what I think is good guidance here is for you to read the Ryan versus Friesenhahn case. It really is more of a social host case, law case, than it is an outdoor industry case. But the reason I chose it, it's a well-briefed case where you'll have the judge's opinion. This is the full judge's opinion. And then after the opinion, you'll see the brief that was written by the authors about the case. And here's your facts, issue, decision, and reasons. So this is just an example for you to use in drafting a brief of the case. So with that, then you would go to the case on page 13 of the book, the Ohio Valley Ranch, and read it, obviously, and draft a written brief, and that will be that's the assignment for next week. I want to correct something that the author says on page 13. He indicates that on appeal, they actually changed the name of the parties to plaintiff and defendant. Actually, what happens in an appeal, if you're the plaintiff and you lost, say you were injured, and and the trial court ruled that the release was effective and keeps you from suing, or resulted in a summary judgment against you, and you want to argue that the release was not valid, then you, as the party that brought the appeal, are called the appellant, and the party who was been the defendant at that time becomes the appellee. So it's not plaintiff and defendant. But so when briefing the case, you want to be sure to, the first thing is, this is common law. In other words, this is judge-made law. So you're looking at a report, and the author does a good job of describing where this report resides, where this brief or opinion resides in terms of what page, it's 784 p second, or volume 784 p second, page 781. Again, a series of books. Lexus system, you can look them up, and he goes through on page 13 how you actually look this up, and this is what you would find. You'd have a full case opinion there. But the reason it's important is those are the cases that then, for instance, on this Heil case, that becomes the law in Colorado, since it's at the Colorado Supreme Court, that we apply when we're looking at the effectiveness of a release of liability in a certain case. So my suggestion in briefing a case is to start with the name, the court it's in, and you can look and see when you look if it's the Court of Appeals, Colorado Court of Appeals, or the Colorado Supreme Court. That way you know at what level. And then I also, in my briefs, I would also start with the date, because you'll look at some of these cases and go, well, that makes no sense this day and age. Well, that's because of the what I want to say, the date in which the case occurred. So start with the court it's in, the name of the case, the court it's in, and the date. I also like to start with the brief of why we have this opinion. And so oftentimes, well, you can say this is an appeal by the plaintiffs who were the injured party from a summary judgment that had been rendered by the trial court, indicating that the release of liability was effective and their case was dismissed. So that you know right off the bat why we have the case, how it got there, and why we're looking at the case. So oftentimes, and then you go through the facts, and I oftentimes read the whole case through first. And a trick I learned in law school is you can use a different highlighter for the facts, for the issue, for the decision, and for the reason, because you're constantly in law school being required to recite what happened in a case, and you need to be able to stand and deliver, so to speak. But even sometimes you read all the way through the case so that you're not trying to brief it until you know what the whole case looks like, so that you don't put in too many extra facts in your brief. You want to really summarize the facts and really articulate only those facts that are relevant to the issue, and then it'll also help you figure out what the issue of the case is. So I do think it's a good idea to read the case through. You can go ahead and start outlining facts, but not try to write your brief as you read it the first time, because I think you'll find if you read it and you understand it, that then you can almost sit back and just draft the brief based on what you know. What you don't get out of it or what you don't understand, you won't understand. And that's what we can talk about in our meeting, like our first class meeting. If there's things you don't understand about the opinion in the Heil case. So in any event, facts, find out what the issue the court was asked to resolve, what was the court's decision, and then why did it make that decision? What were the reasons? And again, you can go through and figure out the important reasons rather than maybe some discussion in the case that's not really that important to the reason. So anyway, that's how you brief a case. The other thing I want to mention as it relates to this assignment is I'm going to ask you to read the dissents. And in other words, in this case, you'll have the court's opinion, and then you're going to have, I think there's three other judges that dissent. In other words, don't agree with the majority. In other words, that, well, they just don't agree with the majority. I'll leave it at that for now. And I've asked you to read those dissents and think about yourself as the operator, the ranch, how you would be in a position to help the attorneys to have drafted the release in a way that would kind of eliminate the dissenting judge's opinion that the release should be held invalid. So in other words, you want to read the dissents and see what they say was wrong with the release, and then you'll be in a position to be able to answer the question, well, hey, I think I could help the ranch as a person that is involved with it help their attorneys draft a release that would not be subject to the same objections that the dissenting judges voiced in terms of their conclusion or belief that the release should not have been valid. So with that, I'm going to end our videos for the first week, and I guess I'll see you on Wednesday evening. All right.